Alright, subpart B, standard security threat assessment 1572-101. Subpart apply with the applicant with the hold to the obtain with the renew with the HME with the TWIC, the transfer the HME with the applicant, the HME, also serve the chief with the requirement issue for the Federal Motor Carrier Safety Administration with L 49 CFR 383 with the issuing the hazard material and endorsement, including additional information, immigration status, and the criminal history stand with the 1572-103 disqualifying criminal offenses. Permanent disqualifying criminal offenses applicant with a permanent disqualifying offense for the convicted of the found not guilty reason the insanity of the military jurisdiction any of the following of the felonies: espionage, criminal conspiracy with the commit espionage, sedition, conspiracy with the commit sedition, treason, commission with the commit treason, federal crime of terrorism, as defined with the Title 18 U.S. Standard Code 2332 with the B, G with the comparable to state and love with the computer with the commit and such with the crime involved with the transportation security engine with the transportation security engine with the issue of the crane including some of the result with the significant loss of life with the environmental damage, the transportation security with the disruption in economic garage with the disruption in the particular area with the age of the line Title 46 U.S. Standard Code 7101 with the term economic disruption does not include the work stop of the other employer related to the action without related to terrorism resulting in employer-employee dispute, improper transposition that has been true with the under the Title 49 U.S. Standard Code 1524 with the state law with its comparable to unlawful possession, use, and sale of the distribution, manufacture, purchase, street transfer, shipping transfer, import, export, surge over the dealing, explosive devices, explosive devices include but not limited to the explosive material defined in Title 18 U.S. Standard Code 232-5 with 8041C, 80 through 84, 841F5 and 844J. Restricted device defined in Title 18 U.S. Standard Code 921A4 and Title 26 U.S. Standard Code 55845F. Murder, marking any threat of the malicious conveying false information knowing the time. Same with the false of the conveyance for the deliverance and placement of the detonation of an explosive or the other lethal device, the agency against a public abuse of the state of the government facility with a public transportation system infrastructure facility. 10. Violation of racketeer with the influence of corrupt organization act with 18 U.S. Standard Code 1961 A and comparable to state law with a predictable act found with a jury with admitted defendant consent insist of the one of the crimes of paragraph A of the section A to attempt with the commitment of the crime of the paragraph A 1 through A4 with the conspiracy to attempt with the commitment of the crimes paragraph A through A5 through A10. Intermittent disqualifying criminal offense of felonies listed in the paragraph B2 of the section of the disqualifying and of the applicant convicted of the found not guilty of the reason for the insane of the crime of the civilian military jurisdictions and with the year of the day of the application, the applicant incarcerated with the release, crime of the release for the incarnation, and 5 year of the day of the AWIC application. Intermittent disqualifying felonies, unlawful possessions, use, sale of the purchase, manufacture, distribution, receipt, transfer, shipping, transportation, delivery, import, export, dealing, and firearm, other weapon, and firearm, and other weapon includes but not limited to firearms, and include defined in 18 U.S. Code 921A3, Title 26 U.S. Code 5845A, and containing U.S. munitions import list, Title 27 CFR 447-21. Extortion, dishonesty, fraud, misrepresentation, including identified fraud, money laundering, where the money laundering is related to crime described in the paragraphs A and B with the section welfare, fraud, passing bad checks does not constitute dishonest fraud, misrepresentation, purpose of paragraph, bribery, smuggling, immigration violation, distribution, possession, intent of the distribution, portion, import and controlled substance, arson, kidnap of the hostage, taking, rape, aggravated sexual abuse, assault with the intent to kill, the robbery. Fraudulent NEC report is described in Title 18 U.S. Code 1036 comparable to state law. 14. Violation of racketeering influence with the corrupt organization act with the 18 U.S. Code 1961 with the comparable state law with the other law of regulation paragraph 810 of the section. 15. Conspiracy to attempt to commit a crime unless paragraph B. And 6. Under warrant indictment and application of the wanted under indictment any of the civilian military jurisdiction felony listed section who's qualified into the warrant over the warrant releasing the indictment dismiss termination arrest status. Fingerprinted base check the scope of the arrest with disqualifying crime list for the section without indicating the disposition of the TW for the notifying applicant provide with the description. Restriction how applicant must clearly deposition conform with the paragraph D2 of the section. Applicant must provide with the TSA with the written proof of the arrest if it does not result in the conviction disqualifying criminal offense. 60 days after the proof of the device of the notification of the D1 section of the TSA if it does not receive the proof of the TSA will notify the applicant he or she with the disqualifying with the case of the HME. The TSA will notify the state if the applicant is disqualified with the case of the majoring mariner applying to the TWIC with the TSA will notify the Coast Guard if the applicant is disqualified. 1572-105. The immigration staff of the individual upon security of the right assessment TWS for the most have of the national United States with the lawful permanent resident of the United States refugee amended to the Title 8 U.S. Standard Code 1157 and legal alien granted an asylum of the Title 8 U.S. Standard 1158 alien of the valid M1 non-immigrating stamp that enrolled with the United States with the Merchant and Marine Academy comparable to state maritime and academy such that the individual is for the gun license parameter documented vessel regardless of the nationality under Title U 46 U.S. Standard Code 8103 non-immigrated alien and admitted with a compact free association between the United States with the Federal State with the Micronesia with the United States with the Republic with the Marshall Islands with the United States with the Pass-Blue alien and lawfully non-immigrants for the unrestricted authorization working in the United States except for the alien valid as S5 with the information criminal organization information lawful non-immigration status aliens valid S7 and information terrorist information lawful non-immigration 3 K1 Phoenicio lawful non-immigration status 4 alien of the K2 minor child with the Phoenicio lawful non-immigration status 7 alien found lawful non-immigration status with a restricted authorization working in the United States. The B1 OCS business visitor Otter County Self C1D crew and visa HB1 special occupation HB1B free trade agreement E1 E-trader either Australian specialty occupation L1 intercompany executive transfer A801 extraordinary ability 9 TNN North American free trade arrangement 10 E2 treaty investor 9 11 authorization for legal status TSA determined the legal status comparable to legal status paragraph A7 in section 8 commercial driver license in the commanded in Mexico amended to the United States under Title 8 U.S. Standard Code 214 2 B412 with the business of the United States C P. Upon expiration of the non-immigrating staff of the list in the paragraph A7 in section employer of the must retrieve the TWSA applicant provide the TSA with the C with the expiration of the non-immigrating staff list in the paragraph A7 in the section employed with the must remember their history of TWS if the two is employer the employer terminates the application work with the non-immigration staff list in paragraph A7 in the section applicant authorized ceases work for the employer, the employer must know for the TSA with the business day of the provide with the TWS if the TSA is possible. And the individual will remove the proceedings subjectly in order to remove the immigration laws of the United States for the non-eligible to the TWS. If the determined applicant's immigration status, the TWSI with a check with the relevant federal database may perform all further checks, including validity, applicants' alien registration number, social security number, I-94, arrival data of the departure from the number. Alright, 1572-107, the other analysis of the TSA will determine the applicant imposed with the security of the right based on the following data, Interpol with the international database, the proprietarious, the related database, and the database related with determining whether the applicant imposed with the subjective imposed with the security of the right confirming the applicant's identity. TSA may determine the applicant imposed with the security of the right with the church going to conduct under the parts of review of the foreign domestic criminal conviction of the conviction with the of the crime not listed in Title 49 CFR 1572-103 period of foreign domestic imprisonment. See 365 consecutive days, mental capacity for 109. Everyone must have the mental capacity that has been the educated lack of mental capacity committed to the mental health facility. Up to the judge educated with the lacking mental capacity with the court board commission lawful authority to determine the applicant with the result of the making as a board. Normal intelligence, mental illness, incapacity, condition of the disease with the degree with himself or the others, lack of the mental capacity to manage his or her own affairs. This includes finding the insanity by the court, criminal case finding with the incompetency with the stand trial, with the finding not guilty with the by rack, reasonable lack of mental responsibility and or any court pursuant to Articles 58 and 76B with the Uniform Code of Military Justice. C. Applicant committed with the mental health facility, he or she was committed with the mental health facility, the court board commission, the lawful included the involuntary commitment, the commitment of lacking mental capacity, mental issue, drug use, does not include the commitment with the mental health facility for observation, voluntary admission of the mental health facility. Subparts 1572, 111 to 139 reserve. Subpart C. Transportation hazardous material Canada, Mexico within the United States land modes.